Coulson Elder Law, proudly serving clients throughout the St. Louis metropolitan area from offices in O'Fallon, Illinois, and the Westport area in St. Louis. And this is your Elder Law Minute. Have you ever had the experience that you're talking about something and you're really familiar with it, and so what you're saying seems simple to you, but you get this look on the face of the person you're talking to that says, not so simple to me? That leads me to talk about something that is simple to me that I realize not a lot of people understand, and that is, what's the difference between a will and a living will? Well, they're actually two very different documents for two very different purposes. The purpose of a will is to determine when you die who's going to get what part of your estate, and also to determine who's going to be in charge of settling your affairs for you. A living will is a document that basically says that when it comes to life-sustaining treatment at the end of my life, that I don't want to be kept artificially alive. Now, a living will isn't a bad thing to have, but unfortunately, a lot of people think it's enough, and it really isn't. What you really need is something called a healthcare power of attorney. Just because you are unable to make and carry out your own healthcare decisions, that doesn't mean that you're on death's door. You may go years after having had a stroke or having Alzheimer's where you need somebody to help make those decisions, or just flat out make those decisions for you. Doesn't mean that you're about to die. You want to have important input into more than just not keeping me artificially alive. So you really need a healthcare power of attorney so that you can be the one who gives somebody a sense of direction, and also gets to choose the one who's going to make those decisions on your behalf. Thanks.